This is the transfer matter, my lord, of the teacher. He has seeking indulgence of his lordship on the basis of medical need, my lord.
On basis of?
Medical need, my lord.
Where is the element? What is it? You never taken that ground?
My lord, I have taken.
Show us that ground in your representation and medical documents.
My lord. Kindly appreciate, my lord, page number 45, 44 and 45, my lord. In the writ petition. 45 and 46, my lord. This is the X-ray report in which the iron rod was inserted, my lord.
What is the ailment?
Grievance is that, my lord.
3 fractures were there.
3 fractures was there, my
It's
lord. 3 fractures were there in his leg, my lord. 3 जगह से उसका पैर टूटा था. He was suffered with the major accident in the.
So when was the accident?
In the month of August 2024, my lord. उसके बाद एक बार दोबारा फिर से हुआ.
ये तो सर्टिफिकेट मई 24 के हैं.
My lord, ये बात का है. ये है, my lord, an exhibit P8 पेज नंबर 53 and 54, my lord.
फिटनेस सर्टिफिकेट दिया कि नहीं दिया ज्वाइन करते समय?
नहीं, अभी नहीं, अभी मेडिकल पे ही है.
नहीं, उस समय
नहीं, उस समय तो दिया था. उस समय
दिया फिटनेस सर्टिफिकेट.
हाँ, उस समय दिया था. और उसके बाद हमने
नहीं,
एक्चुअली माय कंडीशन इज दैट, माय lord, इन्होंने अपने रिप्रेजेंटेशन दोबारा ये जा रहे थे स्कूल, तो फिर से इनका एक्सीडेंट हुआ है.
मोटर एक्सीडेंट क्लेम्स में देखा आपने कितने दिन का मिलता है
मतलब
फ्रैक्चर पे?
एमएससीटी के केसेस नहीं किए हैं, ज़्यादा आइडिया नहीं है. बट माय lord, मैं
फ्रैक्चर पे मैक्सिमम 45 डेज, मैक्सिमम 21 डेज. Normally, heal-up period is 21 days.
If the plates वगैरह.
In worst case scenario, 45 days.
Actually, my lord, my case is that the petitioner was availed the remedy given by the state authority by submitting the so motu voluntarily application on through portal. That is an exhibit P4, my lord. For a moment, kindly appreciate.
Choice filling.
हाँ, choice filling.
But it was required that he should be transferred as
No. I am not claiming. Only I am saying, my lord, कि ये अपनी medical need के आधार पे इन्होंने ये choice filling दिया था.
Not accepted.
That have neither accepted nor refused. He has been transferred to someone else, my lord. And in place of the petitioner.
Since how long he was there?
नहीं, I am admittedly I am since 2016. ये हमने application में भी लिखा हुआ है. P4 में लिखा है कि 31/5/2016 से हम वहीं posted थे. उस चीज़ को हम नहीं dispute.
What do you want?
Lord, I am seeking only to complete
Premature
this.
retirement.
नहीं, रिटायरमेंट तो नहीं होना है सर अभी तो.
रिटायरमेंट ही होगा, ट्रांसफर और रिटायरमेंट, देयर इज नो थर्ड ऑप्शन.
लॉर्ड, इस एक महीने के लिए कर दें. दैट आई विल अगेन मूव द एप्लीकेशन बिफोर द अथॉरिटी, लॉर्ड, ड्यू टू दिस मेडिकल नीड.
व्हेन वाज द ट्रांसफर ऑर्डर पास्ड?
In the June.
June. This is the second round of litigation, lord. Actually, my ground is that, my lord, the authority have not considered the ground which have taken by the petitioner, even which have ordered by this honorable court in the first round of litigation, my lord.
What is the ground taken in the petition?
Medical ground, my lord.
मेडिकल तो अब हो गया पूरा.
My lord.
He is fit for duty.
My lord. But difficulty is there, चूंकि 130 किलोमीटर दूर है तो आना जाना थोड़ा सा दिक्कत.
क्यों आएगा वापस? वहीं रहेगा.
ओल्ड एज मदर इज विद.
मदर भी साथ में जाएंगी.
She is residing in Chhindwara, my lord. That's why making a submission, making a request to transfer him in
Side
Chhindwara.
business?
नहीं, साइड बिजनेस नहीं है, केवल मदर की ट्रीटमेंट और मेडिकल नीड के
साथ में जाएंगी. ऑल विल गो.
एक्चुअली वहाँ मदर पेरेंटल होम में रहती हैं. पेरेंटल होम में छिंदवाड़ा में रहती है मदर. दैट्स व्हाई ही इज.
ठीक है, रिजाइन करिए, मदर का ध्यान रखिए. यू कांट हैव वर्क सफर. यू आर देयर फॉर यू हैव टेकन अ ड्यूटी. टीचर और पढ़ाइए.
एक्चुअली
तो रिजाइन करिए, अपना प्राइवेट ट्यूशन लीजिए.
इवन नो वन हैज बीन ट्रांसफर्ड इन प्लेस.
आपका काम कर रहे थे
अभी सिवनी में थे, सॉरी सिवनी या नर्मदापुरम में.
नर्मदापुरम में काम कर रहे थे, छिंदवाड़ा तो नहीं कर रहे थे.
नहीं, छिंदवाड़ा नहीं कर रहे थे.
जैसे पहले कर रहे थे वैसे अभी करें.
लेकिन अब ये सेकंड एक्सीडेंट के बाद थोड़ी डिफिकल्टी. दैट्स व्हाई मेकिंग अ रिक्वेस्ट, लॉर्ड.
नो ग्राउंड.
ये डायरेक्शन कर दें, लॉर्ड. अब आई विल रेडी टू जॉइन इन द ट्रांसफर, लॉर्ड.
जॉइन by 31st, failing which disciplinary action will be initiated.
फर्स्ट वीक कर दें, लॉर्ड. नवरात्रि के फर्स्ट वीक, अब सेकंड या थर्ड अप्रैल, क्योंकि ये रियलिटी है, लॉर्ड, की डिफिकल्टी है.
3rd April को ज्वाइन कर लीजिए, नहीं तो failing which disciplinary action will be taken.
नहीं, आई एम रेडी.
Counsel for the appellant seeks leave to withdraw the appeal, however prays that time be granted to the appellant to join the place of posting. In view of the above, the appeal is dismissed as withdrawn. Appellant shall join the place of posting on or before 3rd April 2026.
My lord, one more request is that, my lord, kindly may be direct, liberty may be granted to submit the application before the authority.
You will always have in terms of the.
My lord, actually I have filed the P4 and they have not considered. That's why I am making a request.
Failing which disciplinary action will be taken against the petitioner.
My lord, उस ऑर्डर को एजिटेट रहे, उसके लिए हम कोई रिक्वेस्ट, केवल ये रिक्वेस्ट करें साहब कि हम एक नया एप्लीकेशन दे सकें छिंदवाड़ा के लिए.
ऑलरेडी सबमिटेड रिप्रेजेंटेशन.
No representation.
वो P4 का अभी भी पेंडिंग है, कंसीडरेशन में है, my lord. That's why.
We are not inclined. Sorry. Transfer matters we will not interfere.
Great.
Number 20.
My lord, in this, I pray for next week, my lord, my senior will address this court, my lord. He is on the legs of another court.
Request for adjournment is made on behalf of the appellant. That request list after 1 week.
Number 21, Sri Arvind Kumar Pathak.
My lordship, the present MCC has been filed for the restoration of writ appeal number 2622 by 2025, which was dismissed on 9/25 by honorable court
A,
order.
B और C के ground पे
जी
restored and delay condoned.
my lordship 6 days का delay है इसमें. 6 days का डिले है वो MCC
अलाउ कर दिया,
allow कर दिया.
पेटिशन भी डिले भी.
Number 22, Shri Rohit Sharma.
Well, this petition has been preferred against a termination order of a contract which was under the maintenance period. The impugn order is Annexure P18 at page number 160, my lords. So my case is that, my lords, a contract was awarded to me in 2020. Thereafter, by 2022, I had completed the contract. After issuance of the completion certificate, I was under the maintenance period, and maintenance bills were also being raised to me continuously. We were facing certain difficulties, my lord, because the capacity of the road was 8 metric tons, whereas there were vehicles plying of 40 metric tons. We've been raising continuous representations to the department. Consequently, we raised a dispute before the competent authority under clause 24. Now, the moment I raised a dispute before the competent authority, the executive engineer, who is not even empowered to do so, he issued me a show cause notice on 3rd of October, my lords. If my lords may have a look at page Annexure P17 at page 159, my lords. This is a show cause notice issued under clause 52 of the contract agreement. My case is that a routine maintenance contract cannot be terminated under clause 52.
Para clause 24.
Yes, my lords.
Read 24.1.
If any dispute or difference of any kind whatsoever shall arise in connection with or arising out of this contract or the execution of works or maintenance of the works.
Maintenance of works.
Yes, my lord.
Go
My case is you could have issued me a notice, not terminate my contract. My lord, please bear with me for a minute.
There is an alternative dispute resolution
My lord,
mechanism.
I cannot avail that remedy. The reason being, I have already gone before the competent authority on 24. Now, during pendency of that contract dispute, the executive engineer issued me a notice under clause 52, which could not have been issued. My lord, just bear with me for a minute. My lord, if my lord may have page number 97, clause 43.4.
No, this is the maintenance.
Yes.
So
Routine
maintenance is covered by clause 24.
My lord, it may be covered. I have invoked the dispute. मेरा मेंटेनेंस का मुद्दा तो मैंने डिस्प्यूट इन्वोक कर लिया सर. मेरा इशू कुछ और है. My issue is that this termination order is illegal.
So
in terms of
termination
clause
also is also amenable to dispute resolution mechanism.
My lord, but the moment I have been terminated from a contract, my performance security is going to be get forfeited.
All that,
under section
that
17,
can't be a ground. That can't be a ground. You can't terminate if that's a consequence of termination. So be it.
But my lord, with all fairness, my lord, just have a look at clause 43.4, my lords, page 97. If my lords have clause 43.4.
Page 97.
97, my lords.
Yes.
Yes. It says the performance security of 5% of the contract price as detailed in the clause 46 of the conditions of contract is repaid to the contractor when the period of 5 years fixed for routine maintenance is over and the engineer has certified that the contractor has satisfactorily carried out the routine maintenance work. If, and this is important, my lords, if the routine maintenance part of the contract is not carried out by the contractor as per this contract, the employer will be free to get the routine maintenance work carried out from another source and the amount required for this work will be recovered from the amount of performance security available with the employer, or from any amounts of the contract whatever is due along with the additional 20% amount as penalty. So my case is, my lord, this notice has been issued to me under clause 52. Clause 52 states, my lords, if my lords, 52 is at page number 100.
Yes.
It says that the employer may terminate the contract of the contractor in cases of a fundamental breach. This is a notice under 52A, E, F and G. I'll read all 4 provisions, my lord. This is not even a case. My case here is simply...
But that is not what we are going to test.
Absolutely, my lord. But my lord, the basic understanding of DCC has to be there, my lord. The only obligation of the engineer was to issue me a certificate, issue me a notice under 43.4 कि आपने इतना मेंटेनेंस नहीं करा, आप पे इतनी पेनल्टी होती है, अगर आपने नहीं करा तो we'll engage another contractor. On the contrary, they terminated my contract altogether, which could not have been done under the GCC, my lords.
Notwithstanding above, employer may terminate the contract for convenience.
But that's not the clause that they've referred. Plus, my lord, they are duty bound to issue me a show cause notice specifying the reasons for.
So all this will be a ground you will raise.
But my lord, this is a case of illegal termination, my lord. And
Illegal termination is also subject matter of
my lord has come across section 17A in a number of cases, my lord. I need not to reiterate those section 17A. The tribunal does not have the power to grant me any injunction. I am here before.
What is now the tribunal act amended, not amended?
No, not yet.
It's a thing. Act amended, not amended with regard to clause 22.
Presidential assent. We have sent it to the president,
It's still awaited, not notified. But in any case, your dispute will go there.
But my remedy before my lords is that is the only remedy available to me. My lords, reconfirm this fact that 17 is not available to me right now, my lords. Till the time the presidential accent is received, at least till that time my petition will be
Put in a
entertained.
prayer in the petition.
I have raised 2 prayers, my lords. First is direction to the competent authority to decide my dispute first. May I read, my lord, page number 39?
You have not prayed for any interim?
Well, the para 8 interim relief, the clause. As an interim recourse, the petitioner, the Honorable Court may restrain the response from taking any course of action.
So we'll direct them to decide your reference under 24.
But in the meantime, the
There is no prayer in the meantime.
My lord, the reason this
There is no prayer.
Well, I've been trying to satisfy my lords on the issue that this is illegal per se. It could not have been issued.
Maybe. Raise your dispute there.
In that eventuality, my lord, the few drops of blood may be given at least for the time being that my representation is decided by the competent authority. Till that time, they may just
There
restate
is
from.
no prayer.
My lord,
And
the
why should
second
we state? They'll take a cue.
the second prayer is categorically that the set aside the termination order dated.
Termination setting aside will be done by the tribunal.
And my lord, the interim protection that no course of action be taken against me. That's my interim relief, my lord.
Till final, we are disposing of the writ petition right now. Take down. Petitioner seeks a direction to respondent number 2 to decide the reference submitted by the petitioner under clause 24 of the contract. Inter alia seeks cousin. Petitioner was awarded the contract for the work of construction stroke upgradation of rural roads under Pradhan Mantri Gram Sadak Yojana PMGSY-3 in district Hoshangabad, package number MP16705. The contract also included a maintenance of 5 years after the construction was completed. As per the petitioner, the construction was completed on 11/12/2022 and the contract was being executed in terms of the maintenance clause for a period of 5 years. The counsel for petitioner submits that an illegal termination order has been issued. However, petitioner has invoked the alternative dispute resolution mechanism and has approached the competent authority under the provisions of clause 24, subclause 24.1 for resolution of the grievances and closure of the contract agreement. He submits that despite petitioner having done so, the alleged termination order has been issued on 2/1/2026. A show cause notice has been issued on 2/1/2026.
That's an order, my lord.
Termination order.
It's a termination order.
Termination order. Show cause notice was issued.
A termination order has been issued under clause 52 on 2/1/2026.
It's a dispute. It's a dispute.
Issued notice accepted by the counsel appearing for respondent number 1 and you for
2, 3 and 4.
2 to 4. Since petitioner has already given a reference under section 20 under clause 24 which is stated to be pending, we dispose of this petition directing the respondent number 2 to decide the reference submitted under clause 24 of the contract agreement as expeditiously as possible, preferably within a period of 1 month from today. Liberty is also granted to the petitioner to impugn the termination order annexure P18 in accordance with the dispute resolution mechanism in the contract. Petition is disposed of in the above terms. So it is clarified that this court has neither considered nor commented on the merits of the contention of either party. All rights and contentions of parties are reserved.
Get to know.
Number 23 wrong connected case. Shri Parvez Prasad Pathak.
My lord, pass over, my lord. Pass over. My lord, pass over.
Pass over.
Case number 24. Shri Arya Kurmalia.
I'm just praying for some more time in this matter to place the report in respect of the earlier order to be compliant.
What are you seeking?
My lord, this is a PI.
Establishment of free toll-free number.
That's what my lords for Mukti Bhan, my lords. So my lords have directed to examine the feasibility. So I'm just praying some more time in this matter.
The counsel for the state submits that the suggestions given by the petitioner under active consideration of the competent authority and prays for some more time. at request list on 28th April 2026.
Sir, any shorter date में kindly भी गिवेगा, sir.
Sorry?
Any shorter date में kindly भी गिवेगा, sir. Any shorter date में kindly भी गिवेगा.
No, let them take a decision. Government takes time.
Nice. Grateful.
Number 45, Abhishek Singh.
My lord, these are review petitions. I'll first elaborate, my lord, on the scope of the review petition. My lord, kindly appreciate the reference books. 2005, volume 6. Volume?
Which is the order?
Volume 4.
What page is the order?
Order is, my lord, impugned order.
A1. 251. That's the petition. No, that's how many pages? 251 pages, all filed in one.
17.
17A to 70, they've annexed everything in one document. Yes, Mr. Lalwani.
The scope of review, section 114 principles of CPC and order 47. I take directly to my lord's reference 2005, volume 4, SCC 741. It has been filed, it has been uploaded.
Yes.
As I take my lord's directly to para number 89 of the judgment. Order 47.1 of the court provides for filing an application for review. Such an application review would be maintainable not only upon discovery.
Paragraph
89.
89.
Such an application for review would be maintainable not only upon discovery of new and important piece of evidence, or even when there exists an error upon the face of record, but also if the same is necessitated on account of some mistake or for any other sufficient reason.
Who is appearing for the respondent? You are appearing. Yes.
Now, para 90. Thus, a mistake on the part of the court, which would include a mistake in the nature of undertaking, may also call for review of the order. An application for review would also be maintainable if there exists sufficient reason thereof. What would constitute sufficient reason would depend on the fact and circumstance of the case. The word sufficient reason in Order 47 Rule 1 are wide enough to include a misconception of fact or law by a court or even an advocate. An applicant review may be necessary by way of invoking doctrine, actus curia, naming a graduate. Now, I take my lords. My lord, kindly appreciate that para 5.4 of the writ petition. There is no challenge to the rate of the damages allowed by the estate officer and confirmed by the district judge. 5.4. They only say that the policy does not apply to them. They nowhere say that the rates are exorbitant. They don't apply to them.
Where is the petition?
My lord, it's not, my lord, if you come back to the WP and open it, my lord.
It is under the head of my lord LC.
LC, yes. Yes. 5.4. 5.4. That in the year 2014, the respondent has introduced a new policy. The said policy is not applicable for the land plots and so and so, so and so, so and so. The petitioner has been paying the fees while treating as an industrial plot. The respondents, under disregard to the said factual and legal portion, demanded a license fee at so and so, so and so. So it does not say that it is exorbitant. The rates of the policy are not applicable. There's a policy is not applicable. Now I take my lords to another contention. Now, my lord, impugned order may kindly be seen. Two issues were framed by the impugned order. One was about the possession, other was about the damages which was fixed. My lords, at para number 26 of the impugned order, para number 26 of the impugned order. May I read it, my lord? Para number 26 of the impugned order.
Yes.
It says that in view of the above facts and considering the provision of section so and so, we have the considered view that the possession of petitioner has turned into an unauthorized occupation as the license was not renewed at any time after 31/3/2011. This is my lord's holding that he is an unauthorized occupation. Now, my lords, I further take my lords to para 28 की भी पांचवी लाइन में same चीज है. I take my lords to further para, where my lord at 38, para 38. My lords are of the view that since no agreement was executed as per policy of 2014, therefore he was an unauthorized occupant and therefore the policy this policy did not apply to him. This is what my lord hold. In the instant case, if no license deed was executed in furtherance of the policy of 2014, in favor of petitioner and the petitioner running MSM industry, no document was executed between the parties to bring the existing license to the model license agreement. Parties never entered into any contract accordance with the policy of 2014. Now, my lords say that he is an unauthorized occupant because he did not enter into the agreement as per policy of 2014. Therefore, he was an unauthorized occupant.
License period was over, not renewed.
Very correct. I'm just coming to it.
This was the reason.
This is one reason.
Assigning
License period was over. That is true. And he never entered into the agreement as per the policy. Now what I say is, had he entered into the agreement as per the policy, then he would have become authorized occupant. And had he become the authorized occupant, then he would have been paying the rent prescribed by the policy. That is the market rent prescribed by the policy. So that is the evidence of market rate. Now, BHEL unit in Bhopal is about 5,000 acres.
Mr. Lalwani, did you place on record a single document?
I'll answer that.
We have not completed the question.
I understood you. My lords want to know the evidence. I'll come to that. I'm coming to it.
Show us one.
Yes, I'm coming to it.
One document that you had placed on
I'm
record
coming
that the neighbors are paying this rate.
Yes, I'm coming to it.
Show us that straight.
Let me just complete my breath.
Don't show us straight that.
No, let me just a minute.
Mr. Lalwani, we don't have the luxury of time. Please show us
My
straight
lord,
that.
now the case was listed. I'll just take my lords to rule the High Court rules. It says if this case was listed, it was heard. My brother, Mr. Manoj Sharma, appeared. He said that is mentioned also in my synopsis. I gave over the possession part, and for the monetary part, I leave it to my lords. It was heard. It was reserved. Now the rule of the High Court rules can kindly be seen. It says
that the High Court rule may be a reply to this question.
Yes, it says that if my lord wanted further inquiry, further material, something, it could have asked me for that. Why? And that was never asked. Therefore, I am quoting.
This issue was raised at the time of main argument.
My lord, about the rate of mean profit.
There is no material on record to show
perfectly
that the
correct.
are paying
Now I am showing it.
So whether there was a
That
question
is what I am trying to submit. Had he entered into the contract as per policy 2014, he would have become the legal occupant, and legal occupant would pay the rent as per the policy.
This is not the finding.
My lord,
that he would become the legal occupant.
the moment
This finding is of the shop policy.
here I have
what is in respect
here,
of the
my lord, in a land of 5,000 acres, neighboring properties of BHEL, neither BHEL can charge more than the policy, nor it can charge less than the policy. That is the policy. And that is
any evidence to show that any of your occupants are paying rent?
Here I have filed a bunch of agreements.
Show us what have you filed.
Yes, bunch of agreements. Kindly come down to B2. Here I have filed.
172.
Yes, bunch of agreements are filed. They are there. They start from 73. They start from my lord. Yes, they start from. They start from page 21. 50, page 50, man.
50.
Yes, there is a total bunch of agreements which all the BHEL occupiers are paying as per the new policy.
Where is, show us that.
Yes.
Any agreement of industrial plot. Any agreement of industrial
It is
plot.
the shop.
Not small shops. Not small shops.
My lord, industrial plot has also been held by my lords that it comes within the definition of shop.
You just point out any agreement of any industrial plot paying the rent.
I'll flag it and give it to my lords. Let me proceed with the arguments. I don't want to get this case interrupted here, my lord. I'll flag it and give it to my lords. Just let me complete the arguments. Now, my lord, kindly appreciate.
Where is the rent mentioned?
Now, my lord. Now, how the Supreme Court deals with this?
Where is the rent mentioned? And what are the dates of these agreements?
My lord, definitely up to 2014. Anytime whoever comes forward, my lord, this is the date of the time and issue 7/6/19 at page 51.
So this was available with you?
Which, my lord?
These documents were available when the matter was heard?
Yes, what I
You
said.
did not produce them?
I'll ask him.
So we have to request the parties, please give us some material so that
My
we can
lord,
decide.
kindly appreciate it was not fixed. As per the High Court rules and orders, this query was
Take
not
down.
made.
Take down.
I can quote that rule also.
Subject review
My
petition
lord,
has been
my lord,
filed by the
don't
Mr.
My lord, hear me for 2 minutes.
We are dismissing it.
My lord,
We are holding that you are putting the onus on us that we should have requested the
My
party.
lord,
Please produce
let
it.
me just come and let me just cite 1963 also. Let me just cite 1963. I have 5 judgments on the point if there is no evidence on record about the mean profits, about the compensation, user charges, how the court has to deal with it. I'll cite those judgments also.
We have taken a view or challenge it.
My
There is
lord,
not an error.
my lord.
Mr. Lalwani, it is not an error on record. This is a conscious decision by the
My
court.
lord, my
It
lord,
is a well thought
my
over
lord, I am
judgment.
challenging
Mr.
it.
Lalwani, we are not going to spend time on this.
My lord,
it is a well
let me
thought.
just read 63.
Can you read whatever you take down?
My lord, let me just
Sorry,
apprise this court
sorry, we are
about the
dismiss-
judgments, how
Mr.
the Supreme
Lalwani, we are
Court deals.
dismissing the petition. We don't have the luxury of time.
1923.
We have taken a conscious decision. We passed a conscious order, we stand by it, you challenge it.
2023 Supreme Court says in latest judgment that the day the lease expires, a person is liable to pay mean profit.
Challenge it. Challenge our decision. before the
Rector says
Supreme Court.
that. Indian Oil says
This
that.
order doesn't warrant any review.
Vogel 1995 says that.
Please go up in appeal.
MP High Court
Why
71
don't you
says
go up in
that.
appeal, Mr. Lalwani?
That would be
Go up in appeal.
if I can
This
satisfy
is
my
not
lords.
this
Hear me.
is not an error. This is a conscious decision by the court. We passed a conscious order.
Why it is an error I am pointing out. Why it's an error. If there would have been an agreement under the policy, if there would have been an agreement under the
Mr.
policy.
Lalwani, we should have ante status quo, the date of filing of petition, restore possession, we'll consider this. Restore possession. And status quo, what have you done with the property is still there?
Yes, that's it.
Then status quo, ante be maintained, filing of the petition, restore possession, then we'll consider it. He'll pay all damages. You are holding on to somebody's property.
I'll come up with the instructions after to.
No instructions. No instructions
On
now.
this point. Whether
You
my
will
lords
pass
want
the
to me to restore the position, my lords want to hear me again on the merits, I'll come at 1:30 or 2:30, my lord. I'll come back. Only for
Mr.
15
Lalwani,
minutes.
Mr. Lalwani, the only problem was he came up and said, all right, I want to give up my possession.
My
You are
lord,
holding on to crores of rupees of
my lord, he cannot enjoy the property for
However,
penny
Mr.
amounts.
Lalwani, forget
This
about
property
that.
is just opposite
Show
the
us-
ISBT.
Mr.
That
Lalwani,
is at Bhopal.
show us that you have a right of lien over his assets.
Section 8 of the PP8 says that to recover the money, I have to auction these properties.
We've held.
Section 8 says that.
Your order of damages is illegal because there is no material on record.
My lord, permit me to cite 5 judgments.
Show
That
us,
if-
Mr.
in
Lalwani.
absence of any
us.
material, this court has to pass the
Not
order.
this court, the estate officer.
No,
What was the material before the estate officer to determine that damage?
policy.
Policy is not material.
Policy.
is not evidence.
Policy.
Policy is your personal decision.
In BHEL, it is the rate fixed by the policy by the BHEL. It's not only for Bhopal. It's for only Noida. It's for.
Petitioner by the subject petition seeks
Well, let me cite those judgments.
seeks to
Let me cite those judgments.
have a second. Mr. Lalwani, we don't have the luxury of time like this. This was extensively argued, the conscious decision.
That
taken.
was my lords are consuming the time, but I would be supporting myself with law. Kindly let me just give you the judgments.
Mr. Lalwani, it is review. Order has been passed. You
I
challenge.
know, my lord, but review is there only because I can point out that how the damages are required to be calculated when there is no material. I want to point out how the loss is. The damages are to be.
In the petition, it was required to be produce the material before the authority.
My lord, 1963. Yes,
No,
1963.
not at every stage.
One minute.
Thereafter, there
Not
is an appeal.
not 1
Thereafter,
minute.
the-
1963 AIR Supreme Court, that is page number 1405. I take my lords to the last paragraph, para 18. I'll just read 3 lines. The scheduled judge awarded mean profit rate of 140 per mensum, and unless it is shown by the defendant that was excessive, we would not be justified interfering with the amount awarded by the subordinate judge. He has not shown that it is exorbitant.
But there was no material for deciding this.
My lord,
This is our
he has to
finding.
show it.
This is our finding. And it is even this judgment supports us.
Then let me cite those judgments. When there is no material.
Not required in review.
My lord, when there is no material, I cite the judgments. 5 judgments. 5 judgments, not 1. I'll cite 5 judgments.
Say down, renotify on 5th of May 2026.
My lord, contempt is listed tomorrow.
No stay.
My contempt is listed.
Let it-
I have a case.
Let it.
Let
we
me-
don't have the time. We'll hear it in May.
Let me hear, my lord.
Sorry, Mr. Lalwani, we're giving you.
My lord, but decide it so that I can go to the
Yeah,
office.
Mr. Lalwani, go wherever you want to. We're not going to. We don't have the time to hear the matter.
My lord, let me just 10 minutes.
Mr. Lalwani, it is
to
not
lunch.
going to take
Let
10
me just give 5 judgments.
Listen,
5
5th May-
judgments. My lord.
5th May 2020.
My lord, 5 judgments. I am sure that would satisfy my lords. Or one of the 5 judgments, which I consider best. One of the 5.
Not today, Mr. Lalwani.
One of the 5, my lord.
We have specially directed matters after lunch. There is an election matter of the bar association at 2:30. We don't have the
My
luxury.
lord,
today.
I'll just cite 1 judgment of 5.
Not today, Mr.
My
Lalwani.
lord, status quo be maintained.
No.
My lord, contempt petition is
Let
there.
it be. Let it be.
My lord, I'll be missing the limitation also. If I have to
No,
go
no,
to
you have
the
chosen to come in review. You ask for condonation in case your review is not successful. And you are confident you
My
will be
lord,
able to
just
convince
hear
us.
me. Let me cite 1 judgment.
Not
In
today,
this
Mr.
time,
Lalwani.
the consumed, I would have cited by now.
Not
I would have
today.
definitely cited it.
We'll hear you, Mr. Lalwani. We don't have luxury today. We'll have it in May.
My lord, this is also a case, and this affects what is happening now. Let me just it has caused havoc in BB.
You should have gone up in appeal.
No, my lord,
Nobody prevented you
my
from
lord,
going in
my
appeal.
lord, because of this order, the district judges are not giving damages in any case. I have come up in 1 case recently, in not in every case.
Lalwani,
This is affecting whole
Very
of
good
India.
case to- Very good case to go up in appeal.
My lord, this is a, my
choose not to go up in
my
appeal.
lord, when I am confident that my lord will consider
Then
it,
we will hear
why
you,
should go
Mr.
ahead?
Lalwani, we've got 4
Why-
special
why should I
matters,
travel so
and
much?
in election matter where election is tomorrow.
1 judgment, sir.
Sorry.
1 judgment. My lord, contempt may kindly be said.
Let the contempt go on.
My lord, contempt, my lord,
Let it go
both
on.
ways I am nowhere.
Not possible.
This judgment is causing havoc in the BHEL throughout India,
Sorry,
not
Mr.
only here. It may be called here, contempt petition may be called here.
Why should we call it?
Reason being, it pertains to DV. And as per the High Court rules, it should be heard by DV, as per the High Court rules.
You mentioned it before
Chapter
the
20.
contempt court to transfer it here.
Well, the single judge can't transfer to DV. So
can
DV has
always
to call it.
refer- He can, if there is a,
Rule says that.
then he
High Court rule says that.
Convince him. Because judge can find that as per rule, that is
That
to be
may
listed
be
for
alternative, but not the principle.
Thereafter, judicial order by the division bench. And therefore, all,
That
these
only
contempts-
says-
all the contempts are listed before single bench.
That is by Indore bench, I am aware of it, my lord, but that does not take away the rule. That does not take away the rule, my lord. That's if it is contrary to rule, it is parametry.
When judicial order of division bench is there, then
It will be per inquiry, my lord, if it is against the rules. These are constitutional rules.
You'll have it in May. 27 July.
Number 27, say below system.
Your Lordship, in compliance with my Lord's last order sheet, the video is here.